Good morning, ladies and gentlemen. I'm Vijay. I'm a law lecturer at the university and I specialize in labour law. Some other law that I'm acquainted with are corporate law, debt recovery process, business law, contract, and a few other areas. But today we're going to talk about labour law. First, we would like to make a disclaimer. I'm not giving anybody free legal advice. You go and consult your own advocate and solicitor regarding that. What we are trying to here is to enlighten the people about specific legal issues that you may be wondering about. And we will comment on the respective legal positions between the employer and the employee, why things go wrong, the way letters are drafted, domestic inquiries and dismissals, laws relating to poor performance, harassment, victimization, sexual harassment, and the whole lot that the Malaysian employer relations is plagued about with. And I would like to invite you to make your comments by email, or you can comment on this page below, or you can comment by video. I would be most glad to hear from you. The Malaysian scene today is so plagued with employer-employee relations which are so strained that they can't even be settled out of court. As you may not be aware, when things go wrong and employer-employee are not legally entitled to go straight away to the court, that is not the legal position. But you got to go to the mediation process called the industrial tribunal. It's called penselesaian. Try to reconcile. So at that industrial tribunal, the officers will come and say, alright employer, what's your problem? Here's the first side of the story. And then they will turn to the employee and hear, this is what has been said about you. What's your side of the story? And if we can effect out-of-court settlement, then the process stops there. But if it cannot, then the next stage will be, to make it very short, it will be referred to the industrial court after all the preliminaries related to the statement of facts and all those things. Now, first of all, in my opinion, why things go wrong between employer and employee is, number one, like today, the problem we have, I would caution all employees to be honest when they are presenting their CVs to their potential employers. Because there seems to be a tendency these days to overstate your qualifications. My belief is not that you are underpaid, but that you are stated to be overqualified in your papers. So you are legally obliged to be upfront and be honest to your potential employer about your specific qualifications. And the other thing I would like to talk to employees is, if you want to pay peanuts, then you will attract monkeys. This is the Malaysian scene. Employees want the maximum, the best potential out there, but they only want to throw peanuts out there. I want you to say, invest in the potential of your employees. Send them for training. Don't be a tight web. This is the Malaysian system. No? We want the best. We want to get the maximum out of our employees. At the same time, we want to produce very little from our wallets. Right? Just remember this. The employee is not working for you because he loves you. He is there to earn his wages. And you are not keeping him because you got a particular love for him. You are there because you want his performance to perform. And therefore, the legal position is a fair day's wage for a fair day's of work. And a fair day's work for a fair day's of wage. Be upfront. And the second thing I want to say to you is this. The terms and conditions, once it's reduced to paper, you cannot alter it unilaterally by imposing new terms and conditions. This is the basis of our section 102 and 103 Evidence Act 1950. Because once you sign on the dotted line, you are bound by the terms and conditions as much as the employee is bound. So are you. And employers are not above the law. So to avoid any potential misunderstanding, may I offer this sound piece of advice. Put it down in writing and stick to it.